This should not be possible. In a functioning democracy, the director of the FBI does not face arrest by a federal judge. Not as a threat, not as a headline, but as an enforceable reality. And yet, here we are. A judge has issued an ultimatum so stark it strips power of its illusions. Comply with the law or go to jail. No trial, no delay, no negotiation, immediate custody. This is not a scandal. It is not partisan theater. It is the sound a system makes when it reaches the limit of tolerance, when authority is tested and enforcement finally acts. I've spent my life studying how institutions survive pressure. They do not fail when people shout. They fail when rules are optional for those at the top. If you want to understand what happens when the rule of law stops asking politely, stay with me. Because this moment isn't about one official. It's about whether law still outranks power. And to see why this confrontation had to happen, we need to trace the path that led here. To understand what you're witnessing, we need to be precise about what this is and what it is not. This is not a disagreement over paperwork. It is not a bureaucratic delay. And it is not a routine clash between branches of government. This is a direct test of whether judicial authority still has the power to compel obedience from the executive branch when political loyalty interferes. For 6 months, court orders were issued, then reissued. Extensions were granted. Privilege claims were reviewed carefully, repeatedly, and rejected by multiple federal courts. Each time, the response was the same: delay, deflection, and refusal. At some point, a legal process stops being procedural and becomes existential. Because when court orders can be ignored without consequence, law itself becomes optional. And optional law is not law at all. That is the line this judge decided had been crossed. The question now is no longer whether documents will be released. It is whether any official, no matter how powerful, can place themselves above a lawful court order and survive the confrontation. To answer that, we have to look at how this confrontation was engineered over time. Power struggles like this never appear overnight. They are built slowly through precedent, habit, and tolerance. For most of modern American history, contempt of court has been the judiciary's last line of defense. Rarely used, almost never public. Its power lies not in frequency, but in inevitability. When courts issue lawful orders, compliance is assumed, not negotiated. But over time, something shifted. Executives learned that delay could substitute for defiance, that privilege could be stretched beyond its purpose, that political loyalty could act as insulation. Each successful delay trained the system to accept a little more resistance, a little less accountability. This case followed that pattern exactly. Initial orders were ignored. Then came extensions. Then privilege logs. Then appeals already decided by higher courts, repackaged as new objections. None of it illegal in isolation. All of it corrosive in aggregate. What you are seeing now is not judicial aggression, it is judicial exhaustion. Courts function on the assumption that their authority will ultimately be respected. When that assumption fails, judges are forced into a role they are designed to avoid: enforcers of last resort. And once a court reaches that point, the confrontation becomes unavoidable. That brings us to the moment when procedure ended and crisis began. The breaking point arrived on December 17th. Not with chaos, not with shouting, but with something far more dangerous to power: calm enforcement. At 2:47 p.m., a federal courtroom became the stage for what may be the most extraordinary contempt hearing in modern American history. A sitting FBI director was summoned not to explain, not to negotiate, but to answer a single, unavoidable question: will you comply? For months, the strategy had worked. Documents were labeled privileged, claims were recycled, time was consumed, but federal judges are not members of Congress. They do not posture, they enforce. When the judge asked the question directly, there was no room left for ambiguity, no legal shelter remaining. Every privilege claim had already been rejected, every extension exhausted, and in that moment, the system demanded a choice. Not from the FBI as an institution, not from the executive branch as a whole, But from one official in real time, under oath, the hesitation mattered more than the words, because hesitation at that level is defiance. That was the instant this stopped being a procedural dispute and became a constitutional crisis. And to understand why the judge responded the way he did next, we need to examine what was really being withheld. What was being withheld was not dangerous because it was classified. It was dangerous because of what it revealed. The mechanism at work here is one I've seen repeatedly in institutional failures, the misuse of protection tools to achieve political outcomes. Privilege exists to protect legitimate state interests. Classification exists to protect security. Confidentiality exists to preserve investigations. But when those tools are repurposed to shield individuals, they become instruments of obstruction. That is what the court concluded had happened. Multiple judges reviewed the same claims and reached the same determination. The documents were not classified, not privileged, and not part of any active investigation. The legal justifications collapsed under scrutiny. What remained was delay without defense. This is how systems are quietly bent, not by refusing openly, but by drowning enforcement in process until authority gives up. It is slow, it is technical, and it depends entirely on one assumption, that no one will force the final step. Judge Berman did. By stripping away every procedural shield, the court exposed the real conflict. Not secrecy versus safety, but accountability versus protection. And once that conflict was visible, enforcement became inevitable. That inevitability set the stage for the second escalation, one far more consequential than the first. The second escalation was not louder. It was final. When Judge Berman set the deadline, the tone of the entire system changed. No more hearings, no more motions, no more legal theater, just a clock and consequences. December 20th, 5 p.m. That deadline did something unprecedented. It collapsed uncertainty. For the first time, the FBI director was no longer maneuvering inside a process. He was standing outside it. And outside the process, power disappears quickly. The judge was explicit. Miss the deadline, and federal marshals would take the FBI director into custody immediately. No appeal, no delay, no special treatment, detention until compliance. This is the moment many misunderstand. This was not judicial overreach. This was the judiciary reasserting the one power it must never lose the ability to enforce its own orders. Without that power, courts become advisory bodies. With it, they remain constitutional anchors. The ultimatum did not escalate the crisis. It clarified it. There were now only two outcomes left: submission to the rule of law or incarceration. And that clarity sent shockwaves far beyond one courtroom. Now, I want you to think about what this means for you, because constitutional crises don't begin in courtrooms. They begin in ordinary lives, when rules stop applying equally and power starts deciding who is accountable and who is not. If the director of the FBI can ignore lawful court orders without consequence, then the law you rely on every day becomes conditional. Conditional on status, conditional on loyalty, conditional on who you protect. That erosion doesn't announce itself with sirens. It shows up quietly when trust disappears, when institutions feel distant, when people stop believing that fairness is real rather than performative. You are told the system is strong, that checks and balances still function. But systems are only as strong as the moment they are tested. This was that moment. And here is the uncomfortable truth. What happens next will signal whether the rule of law still applies upward or only downward. If this matters to you, if you care about living in a society where power answers to law stay engaged, share this, pay attention, because silence is how erosion becomes collapse. And to understand why this moment resonates far beyond American borders, we have to widen the lens. The world is watching this not as American drama, but as institutional evidence. For decades, the United States has presented itself as a system governed by law rather than by loyalty. Courts independent, enforcement neutral, accountability universal. Those claims carry weight only if they survive moments like this. When a nation's top law enforcement official defies a federal court, allies take note. So do adversaries. Because credibility is not built on speeches, it is built on enforcement. If judicial authority fails here, it signals that political power can override legal constraint. That signal does not stay domestic. It travels into trade negotiations, security alliances, and diplomatic trust. I've advised governments across the world, and I can tell you this: the fastest way to lose moral authority is selective accountability. Once a country tolerates it internally, it cannot credibly condemn it elsewhere. This is why the stakes extend beyond one case or one official. The outcome shapes how American institutions are perceived and whether their rules are treated as real or rhetorical. What comes next will determine whether this confrontation becomes a reaffirmation of law or a case study in its limits. To see that clearly, we need to look forward. From here, the system has only three possible futures. The first is compliance. The documents are released, the confrontation ends. In this scenario, the system absorbs the shock and reasserts a simple truth: no office outranks the law. It is stabilizing, but not painless. Because compliance would expose what delay was designed to conceal, and accountability would ripple outward. The second future is arrest. The deadline passes, enforcement follows, the FBI director is taken into custody. This would trigger an institutional earthquake, temporary paralysis, political backlash, legal chaos, but it would also establish something profound: that judicial authority is not symbolic. It is real and enforceable. The third future is the most dangerous and the most subtle. Delay without consequence, defiance without enforcement, a quiet retreat framed as compromise. This is how systems hollow out while appearing intact. The law remains written, but no longer feared by those at the top. History shows us this pattern clearly. Democracies rarely fall from sudden collapse. They erode when enforcement becomes optional and power learns it can wait out the rules. Which future emerges will not depend on rhetoric. It will depend on whether the system follows through. And that brings us to the final insight, what this moment ultimately reveals. What this moment ultimately reveals is not who holds power, but whether power still answers to law. Every system reaches a point where it must choose between convenience and consequence, between preserving appearances and enforcing principles. This was that point. A judge did not create this crisis. He exposed it. By refusing to retreat, he forced the system to declare what it actually believes. If compliance happens, the message is clear: the law still governs upward. If arrest happens, the message is even clearer: enforcement is not optional. But if neither happens, if delay is rewarded and defiance survives, then something far more damaging will have occurred. The rule of law will still exist on paper, but not in practice. That distinction matters. Because once people stop believing the law applies equally, they stop trusting institutions entirely. And when trust collapses, democracy follows. I've studied this pattern across continents and decades. The warning signs are always the same. The ending is not inevitable, but it is predictable if ignored. So don't treat this as news, treat it as a test. If you want to understand what comes next, how accountability either reasserts itself or quietly retreats, stay with me. Share this. Stay engaged. Because the future of the system is being decided not by rhetoric, but by enforcement.